This is a video I put together that shows some clips from a Zoom hearing that I didn't participate in, and also decisions from 2018 to 2019. So this is the 19 decision. So it's rather convoluted how they come to the conclusion that they had to raise the house $130,700 because I remodeled a master bedroom and a bathroom and one other small bedroom. So enjoy the show. Here we go. And most of the remodel did occur in 2016. But I never knew that they were going to make these brand spanking new allegations. So it got rather convoluted. The 2018 was more about they made assessment errors for 16 and 17. So 18, they corrected their own assessment errors, included 75% of the remodel. It's in writing. This was even submitted by the respondents, but they didn't pay attention to the last paragraph sentence. In addition, the taxpayers have remodeled most of the main floor. And this is the main floor. I never anticipated I was going to have to show them dated photographs for 2018 or 19. Now I did for 2020. I proved to them with dated photographs that everything was completed in 2016, except the master bedroom and bathroom. That was the only remodel for the 2019 tax year.
This is a difficult way to proceed without the petitioner, because we don't know for certain what he wanted to emphasize in his exhibits and what he wanted to actually present.
That last photograph was submitted as evidence and they removed it. And this one was sent to him 41 days before the Zoom hearing from my attorney, so he knew exactly what the only changes were for the tax year. Coming up next are some clips from Tim Bodley's PowerPoint rant. Went on for 20 minutes. Why the significant raise in house value.
I do want to emphasize why there was an increase in value. It had nothing to do with anything other than in 2018, because of the remodel upstairs, the county had assessed it as only 75% complete. So in other words, they assess it as if it was under construction. Fully recognize that only the upstairs, which is the most important part, was fully remodeled in 2018 for the most part. The 100% complete is simply that construction is done. Next slide. Petitioners do carry the burden of proof to show material error. Actually, I think that should be substantial error, and a sound evidentiary basis in the BOE's decision, which sustained the assessment.
Well, the burden of proof is on me. At no given time before this hearing did anybody ever state that 75% was still under construction. So it was unfathomable that they even made that allegation. And at the closing of the case, Tim Bodley motioned to close the evidence of the portion of the hearing, so I would not have the opportunity to object and rebuttal and prove that he committed perjury in this formal hearing. It's utter nonsense what's gone on. In other portions of the Zoom hearing, they actually say that they were not allowed an inspection. So they don't understand, they don't know really what it is. So how do they make these assertions? It's borders criminal. It's criminal misconduct when you state one thing that means absolutely nothing in the meaning of now they know what was completed. What they know is because I told them that 75% was completed in the prior tax year in my email the day before.
For whatever reason, seems to confuse this 100% with meaning that the county has determined that the property was 100% remodeled in 2018. That is not the case. We fully recognize that only the upstairs, which is the most important part, was fully remodeled in 2018 for the most part. The 100% complete is simply that construction is done. And yes, the basement is older, but construction has been done and was done some years prior to that. So the taxpayer, the petitioner, seems to confuse the 100% complete with somehow a misunderstanding that we mean by that we assume that the whole house was remodeled 100%. Is there any question on that, Your Honor? Does that explanation make sense? If not, I'll move to the next slide. Here on this page, is this helpful at all?
It looks like it kind of goes back to the same thing as previous.
Oh, go ahead.
The equity argument and the increase argument is hard when the subject property has been renovated, and so I don't think it's appropriate to say, look how much mine's gone up versus someone that hasn't been remodeled, if that makes sense.
All right, let's move to anything else you need to add here, Mr. Walcott?
No.
Let's move to exhibit 3 real quickly.
Mr. Watcott's original prognosis said 75% complete, moved to 100. It did not say that the 75% was still under construction. This intent was clearly to show the differences in inflation rates between ours and all of our neighbors, and Mr. Watcott ignored that and went right to it's because of the remodels that did occur for the 2018 tax year.
They refused an inspection, and then this is another problem, Your Honor. By the taxpayer's own admission, and it's in the appraisal that he submitted, the appraiser was not permitted an inspection either. And then subsequently, the appraiser did communicate with the county and asked that the appraisal not be used and not be considered. We'll testify and offer evidence that our assumption is that was partly done because the appraiser learned that the upstairs was in significantly better condition than what was represented to him and what he assumed in his appraisal, and you'll see the adjustments there, and we'll discuss that when we get there.
That last clip was submitted to the Tax Commission and to all respondents on March 3rd. But then this is what showed up, or didn't show up, that I submitted for the hearing when they were going to discuss it. So they excluded showing this one with my comments. There's something super fishy going on, whereas the secret, what did my appraiser tell the commission? That it was better condition.
Is that he does ask for opportunity to respond to our evidence, and I don't know how the commission wants to handle that, because this could go on forever through emails and responses. This was the time certain for the taxpayer to present his rebuttal evidence, and I think the commission should close the evidence portion of the hearing at this time, and that would be my motion.
And we'll grant that motion and close the record. We'll take the information received under advisement. The commission will issue a written decision, and that decision will include appeal rights available to either party.
All right. Thank you for your time, and I'm sorry it was complicated, but the Zoom did help, so I appreciate that, Your Honor.
Do it. Thank you.
I was exponentially biased and prejudiced beyond imagination that a commissioner would grant something like that when I specifically stated I reserved the right to rebuttal to anything. But it makes sense. Tim Bodley knew he concealed evidence and committed perjury in this hearing, which is a third-degree felony when you remove items and you make false assertions and allegations. Coming up next is a status conference call with Tim Bodley, Brian Watcott, and Judge Clinton Jensen. As for the appeals court, there are two different jurisdictions. They excused it because I was inadvertently late.
Okay, so you're going to go ahead and go to full trial. They call that a trial de novo.
Absolutely. I have undeniable evidence that Bodley and Watcott basically lied about the improvements made. Geez, if you go back, well, it gets very personal. It gets very personal. I didn't participate in that hearing because I was sick, and I did write out that I reserve the right to respond and rebuttal to anything I disagree with. So they closed the case anyway. That was about as biased and prejudiced as it gets. Coming up is part of a status conference call with Judge Jensen, Tim Bodley, and Brian Watcott. You're an administrative law judge, right?
Yes.
You're also an attorney. You're also an attorney, right?
That is correct.
Well, then let's abide by the laws. You know, another law that doesn't make sense is in 59-2-106, the last paragraph says the commission shall decide all appeals taken pursuant to this section no later than March 1st of the following year for real property. So these matters 2020 should have been decided last March.
And we, of course, cannot do that because we need a decision on the 2019.
Well, that's where it just gets more confusing when you have to file for reconsideration. They denied it without any logical sense to it. Everything I submitted cited why it should be reconsidered. It was an impartial. It was a very impartial hearing by Canon Rule 2.2. I was dumbfounded that Commissioner Cragen agreed with Bodley's motion to close the case. That should have been taken under advisement.
I have good news for you. When you go to district court, it's a brand new hearing. You present brand new evidence, anything you want to present, and you just present your case there.
And that's exactly why I did it.
All right. Well, it sounds like we're all in agreement then. We can't do anything with the 20 and 21 just yet. And so what we better do with those is just give you time to work your way through the district court.
Sorry, Your Honor, I do need to clarify that. No, I didn't realize that was on food. No. So the 2019 is final as a matter of law. He did not timely file it anywhere. And he did file it late with the Supreme Court, and it poured over the Court of Appeals, and they issued a final decision.
They excused it because I was late, not by anything of evidence, Tim. Let's go by the evidence. That excusal is not even related to a civil court hearing.
So, Your Honor, I don't, he can file as much as he wants regarding 2019, but it's done. And I'm happy to submit the Court of Appeals decisions, but that's over, so we need to move forward to 2020 at this point and just have a hearing on that. I'm sorry I was on. You'll have a chance to get up to court and explain why you saw the evidence 51 days before the Zoom hearing, the only changes for it. That was sent directly to you from Ephraim Olson. So we'll certainly hear whatever evidence he's got for 2020.
You're gonna hear evidence for 2019. in district court. You already were served notice. I'm not going to put up with all your baloney anymore.
That's fine. Let's look for, Mr. Keogh, do you have a current filing with the district court that will give you a decision on this?
It has not been filed. By the letter of the law that I filed it, it's good for 2 years. There's no deadline once you give them the 60 days notice.
So your Honor, and I'm sorry, Your Honor, I don't mean to make this more difficult than it needs to be. He's referring to a notice of a governmental claim under the Governmental Immunity Act. Like if you have a tort or something, you have to send notice to the government first, and then before you could file a district court. That has nothing to do with the appeal of a tax commission decision. That is 30 days.
It's obvious you don't want the case to be heard bodily. It says you submit a brief why the case should be heard. The brief I sent was 24 pages long.
We just need to move on to 2020, and he has every right to make the arguments he wants to that tax year, and he's kindly preserved that appeal before the commission, and I think you just need to schedule a hearing.
Okay, well, we have today scheduled for 15 minutes, and we've used up 14 of it. So what I'm going to do is I'm going to schedule this for a hearing. We can either have an initial hearing or a formal hearing. And Mr. Keogh, you have every right to make these arguments there if you'd like. That way we'll have time to hear them.
You'll have a chance to argue 2019. Do not file a date for a formal hearing with the tax commission. This is even crazier. When we had a status conference call on May 26th on the commercial property, I told all the parties that I would take that to civil court too. And what did Jane Fan do? She started a formal hearing for it. So I'm right on the cusp of serving notice to take that to civil court too. You did not listen to what I just said.
I heard you, and but I don't agree with you.
Oh, so
you have a right to be heard.
You're okay with an unbiased, impartial hearing? That's what 2019 was. We need that for 2019. 2019 in district court will be an impartial hearing. And Budley and Watcott can get up there and explain why they feel like they should jack up the house $130,700 because I remodeled the master bedroom. That is not a qualifying change by the face of the law.
All right, well, I do need to move on to another matter. And so I'm going to do that, and I'll send notice of the next proceeding, and we'll have more time for that one. My apologies that I do have to cut the parties off today, because I really do need to move on to another hearing. So I'll set this for an initial hearing, and I'll give sufficient time for that.
All right, thank you, Your Honor.
And the case will be filed in district court in the next couple of days.
And we'll talk about that at the hearing time. Thank you all.
All right, thank you.
This whole thing's a joke.
Everyone else has left the call.
What a joke. Administrative law judges, do you affirm under penalty of perjury your testimony would be the truth? He attacks me. This is the 2018 prognosis that the 19 guys submitted. Clearly states 75% was complete for the lien date, 2018. They don't even read their own stuff before they submit it. If you don't like the outcome of a commission formal hearing, they offer you two remedies: reconsideration and or appeals court. I've done both. So the other remedy, which they don't even mention, is district court. It even is mentioned in the commissioner's website. So anyway, I did put them on notice on May 9th, 2022 to take it to district court. And you have 60 days before you can actually file it. And they are supposed to acknowledge and send receipt that they received it. Only the tax commission did. So now where this stands, they want me to prove that I have a case, which I only have a brief. Doesn't expire for 2 years. So I did file quite lengthy reconsiderations for the decision. They ignored it. I submitted all the new evidence that was concealed or removed from the hearing, and that would be the focus point of a trial de novo. So the only place there's going to be justice is district court with a jury if I want. I did submit the transcript of that status conference call to the tax commission with a lot more reasons why they should put it on hold. And unknown if Judge Jensen read it. It wasn't added to any of the emails sent to the opposing party. Nonetheless, this is what he sent me and them. They don't want trial in district court, but he's asking me to send specifically pending actions. They already received the notice of intent to file it in district court. And again, I have 2 years to file it. If that doesn't sway them to stop the nonsense, I don't know what it will. So I put together this video just to show them inconclusively how corrupt the 2019 decision was. And in district court, they'll strike down based on the facts, and all further proceedings will be subject to the median inflation rate, which the home should have been after 2018. So it's quite the rodeo ride. Let's keep going. You can also seek damages from district court. It's right in the law. In Judge Jensen's last paragraph, he says that no legal argument. Well, the legal argument is that I did file a petition, which is up to me when I decide to file it as a case. The canon laws govern judicial judges. You'll note there that I am supposed to get a fair and impartial hearing. That didn't happen. This was submitted by the respondents at 2018 BOE, and I highlighted in red, applied a complete adjustment to the entirety of the improvements. They submitted multiple 2018 decisions. They excluded the ones that I've presented here for a reason. And now that both decisions are exposed, you see the significant conflicting paragraphs. It's unbelievable. They don't even read their own paragraphs to come to a logical, fair, and impartial hearing. The respondents did furnish this paragraph 10, the last paragraph, but they did not mention what I underlined. This law 59-2-1006, both decisions note parts of this, but not paragraph 6. That is one very abused law for all appeals. They didn't furnish their own 2019 prognosis because it clearly stated 75% complete for the 2018 tax year. When I submitted the email showing the 25%, they removed it. If you just pay attention to the two decisions for both tax years, the conflicting statements are pretty easy to interpret. So another alternative is called the hidden fourth branch, a corrupt government's worst nightmare. A grand jury reviews the case. It takes it out of the government's hands. That's probably the best remedy. It's not very well known. We're still working on digging into that one. Thanks for watching.